stop committing these, but also provide reparations for victims and to punish the perpetrators, including senior government officials and military officers. Now, they've also requested preliminary measures from the court. So what they've done is they've said, in the meantime, we want the ICJ to order Myanmar to stop committing the actions that are part of the genocide campaign at the moment, including killings, physical abuse, destruction of villages, and sexual violence. So this preliminary request is really quite important. Recent assessments have found that the risk of genocide and other atrocities is very high and also ongoing. So we have this first very exciting development that happened a few days ago, and then last night I had to make changes again to the presentation because something else happened. So recently, the Office of the Prosecutor of the International Criminal Court took an extraordinarily creative initiative to start a process under which the ICC may be able to take accountability option for individual criminal accountability. So the OTP, the Office of the Prosecutor, formally requested from the ICC to determine whether the ICC would have jurisdiction over the crime against humanity of deportation of Rohingya from Myanmar into Bangladesh. Now, Bangladesh is a state party to the Rome Statute, and so the ICC has jurisdictions over crimes that are committed within its territory. But of course, as we know, Myanmar is not a state party, as you can imagine, to the Rome Statute of the International Criminal Court. So this was a really creative way for the prosecutor to think about how could we somehow get some accountability at an individual criminal responsibility level. So the prosecutor argued that the Rohingya have been deported from Myanmar. They said attacks directed against the civilian population were well organised, coordinated and systematic and intended to drive the Rohingya population out of Myanmar. So this was key, this idea that they are moving from Myanmar into Bangladesh. Now, the request is based on the fact that the crime of deportation contains a legal requirement that the victim is forced to cross an international border. So in circumstances where the enforced border crossing takes the victim directly into the territory of another state, the legal element of the crime of deportation has been completed in the second state. So part of the crime is this compulsion, compelling the victims to enter another state. So the prosecutor argued that at least one legal element of the crime was committed in Bangladesh in accordance with general legal criminal law principles that require only one part of the crime to be committed in a state's territory, whether it be begun in that territory or the effects were felt in that territory. So the ICC responded that it has jurisdiction in this particular situation and said the prosecutor could open a preliminary examination. So that was only preliminary though. So they agreed, yes, the crime of deportation requires crossing over into another state. So the prosecutor then conducted a preliminary investigation, and in July, on the 4th of July this year, she submitted a request for authorization to open an investigation, a formal investigation into the situation. And she based this request on the crimes of against humanity of deportation, other inhumane acts, and persecution based on grounds of ethnicity and or religion. So yesterday, last night, Bangladesh time, the pretrial chamber authorised this request for an investigation. So this was really interesting, and it was 58 pages, so I've done a cursory read as it was literally 9 o'clock last night and I was very jet lagged. But basically, it's quite extraordinary because what the pretrial chamber has said is that essentially they've given an open book to the prosecutor because it's only an investigation. So they said, we don't want to restrict the prosecutor's remit too much because the prosecutor is going to need to explore more what is happening in the investigation itself, which makes sense. So basically they said, they agreed there's a reasonable basis to believe that widespread and or systematic acts of violence have been committed. And so therefore, what they said was, we're not going to limit this investigation to only those 3 crimes that the prosecutor requested. So they've actually granted the prosecutor the remit to investigate any crimes under the Rome Statute. So this opens up the possibility that ultimately when they go to trial, there could be genocide charges included. So what they've also said, so the prosecutor requested jurisdiction from crimes that were committed from October 2016 onwards. But because Bangladesh became a state party to the Rome Statute in July 2010, on the 1st of July 2010, the pretrial chamber has said, actually, you can investigate any crimes committed within the context of this situation that happened from the 1st of July 2010 onwards. So they've actually given the prosecutor a bigger remit than she asked for. And the third thing that they've done that's quite significant is they've said, because we've got these crimes that can be committed across state borders, we're not going to limit the jurisdiction to Bangladesh. So the prosecutor is actually open to having a look at any other country that is a state party to the Rome Statute where these crimes might have continued. So if you take, for example, a colleague and I have been looking at the situation of Rohingya refugees in Malaysia, where they have been subject to forced assimilation and essentially lost their identity as Rohingya. So if Malaysia were a state party, they too could also be considered in that. So it's really quite an amazing ruling decision from the pretrial chamber that has given the prosecutor a really broad remit to investigate this. So basically what the court said was that we have a situation that is of sufficient gravity for the court to have jurisdiction, and that it definitely serves the interests of justice. The pretrial chamber referred significantly to the submissions that were made on behalf of victims, and there essentially were hundreds of submissions made on behalf of thousands of victims. So they said this is a huge, huge case. We're talking about hundreds of thousands of victims. We're talking about crimes committed systematically and particularly importantly by the state, and that there's evidence of state policy to destroy the Rohingya. So obviously this is not a judgment, but it's a really important step, and we now wait to see what happens with the investigation and where the charges will go from here. Thank you.
Now, I'd like to thank Dr. Milena O'Brien for her presentations on the question not only of genocide, but how to make those perpetrators accountable to justice, and various options she has laid down, and the role of the Bangladesh situations. She also told about the other countries in the region who can do that. Perhaps Australia can also play a role. For the purpose of the investigation, Dr. Milane has also mentioned about the investigation team, whether the number of jurists in the region could have a investigation, public investigations, which of course may not have the legal credibility for the purpose of the prosecution or not. So I'd like to get your opinion on that, if you'd like to respond to that. Investigation. So could you mention that? Yeah, we could do that. That investigation.
Do you want to wait for the discussion, or?
That's just for your response. That you mentioned about the investigation, which can be conducted without any umbrella of the UN authority.
Sorry.
Without the umbrella of the UN initiative, whether the jurists in the region, they could initiate an investigation in this regard, which may have credibility or may not have the legal standing.
Do you mean like domestic lawyers?
Yes, in the region,
Okay.
like Australia, Malaysia, Bangladesh.
Okay. So I think if I understand the question is whether domestic lawyers in other countries could instigate proceedings. It will depend on the country's legislation in terms of universal jurisdiction. So Irene talked about the action in Argentina, which has just been filed by local lawyers and NGOs. And that's because Argentina does apply universal jurisdiction, but not all states have universal jurisdiction options under their legislation. So it may not necessarily be possible in all countries. It would depend on whether they have that option because, for example, they may have extraterritorial options but not necessarily universal jurisdiction, meaning, and again, Irene talked about trials in absentia. They may also not allow for that to start a trial without the accused actually being present there. So given that the perpetrators generally, as far as I know, tend not to leave Myanmar, it makes it quite challenging because we can't then apply principles like aut dedere, aut judicare, which is extradite or prosecute, meaning that you have someone in custody and so you can then prosecute them or you extradite them back to the state that has territorial jurisdiction. So that isn't really an option because they're simply not leaving Myanmar, with the exception of Aung San Suu Kyi, but then you have head of state immunities at play as a problem that could block that as well.
What would be your response to the status of Bangladesh, who is harboring this unexpected huge population now in Bangladesh, whether they may have an obligation to investigate these matters?
Yeah, and this is something, because I only had 15 minutes, but when I get 20 minutes, I have a slide that includes this, because actually what Bangladesh could enact is international jurisdiction where they seek to protect their own nationals. Because of course, this huge influx of hundreds of thousands of people, possibly up to 1 million people, is challenging for Bangladesh, but also creates security risks. So under that, Bangladesh could actually take action and say, we're looking to protect our security interests and also our local population. Not in that sense demonizing the refugees themselves, but of course, the crimes that are being committed through organised crime in the area and things have increased because of that. And we all know that just a mass influx of people does create a security situation. So definitely there is scope there for Bangladesh to take action. But again, whether or not they could actually get the perpetrators in person here would be another thing, yeah. But I would like to encourage Bangladesh to support the Gambia's filing before the International Court of Justice. Mm-hmm. They should do that.
I'm continuing some correspondence with the UN system.
Right.
So they're also responding to that.
Okay.
So I was wondering that whether Dr. O'Brien might have some time in order to help and advise us how we can do, make a team in order to do it. Because, international law has emerged not only in a very structured manner, but also it has emerged because of the necessity. And if the genocide itself, and it's being a crime, that also has been really created by the jurists themselves. That's 9 pages of genocide. Yeah. So those have been also, the law has itself emerged that way. So I wonder whether Dr. O'Brien could give us some valuable time to that.
Yeah.
Thank you very much. Now, Mr. Regan, no?
Pizwa.
Huh? Pizwa. Now we have the role of the future of justice for genocide. That's exactly I initiated. Perspectives of Bangladesh genocide and Myanmar's Rohingya genocide will be presented by Mohammed Pizwar Hussain. lecturer of the East-West University.
Thank you, sir, for giving me the floor. Good afternoon, ladies and gentlemen. This is Mohammad Pizur Hussain. I'm going to give my presentation on my research paper, which has its own title, and the title is Justice for Genocide, Perspectives of Bangladesh Genocide and Myanmar's Rohingya Genocide. I have divided my paper into 4 parts, but I'll be trying to focus on the Bangladesh genocide trial aspects more because my previous speaker, Dr. O'Brien, has already covered all the aspects of justice of Rohingya genocide. I'll start with the definition of genocide because I can understand that I need to give the definition first and then I can proceed with the detailed presentation. So in order to define genocide, we need to divide the definition into three elements just for the sake of understanding. And the first element is special intent, which is required to commit genocide. And it means that the perpetrators must have a special intent to destroy the protected group, either 1 or 2 groups or all the protected groups as per each case. And the destruction can be either in whole or in part. And the 4 protected groups as per the Genocide Convention and most of the international laws are national, ethnic, religious, or racial group. Since I'll be covering the Bangladesh aspect as well, so I'd like to inform that the International Crimes Tribunal Act of Bangladesh, this act introduced another group within the ambit of the protected group, and the group that has been included is the political group. So the Genocide Convention, Rome Statute, all these treaties and conventions, they have included 4 protected groups, whereas Bangladeshi law, which is International Crimes Tribunal Bangladesh, has added 1 group, that is political group. And we will see that in many of the cases of the International Crimes Tribunal of Bangladesh, there were some charges in relation to destroying the political groups by the perpetrators. The third element of genocide is genocidal acts, and acts are limited to 5 acts, but sometimes it depends on interpretation. The first act is killing members of the group, secondly, causing serious bodily or mental harm to members of the group, thirdly, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, fourthly, imposing measures intended to prevent births within the group, and finally, forcibly transferring children of the group to another group. Why these acts are needed to be mentioned in my presentation? There is one reason, because in Bangladesh, we usually have an understanding that whenever genocide happens, we understand that genocide means only killing. But as per the acts concerned in the conventions and even in the International Crimes Tribunal Act of Bangladesh of 1973, killing is one of the acts which is considered as genocidal act, but all other 4 acts, these are not related to killing. So even without killing, genocide can be committed, and I'll be describing it later when I'll describe the trends of Bangladesh aspects of genocide trial. So starting with the International Crimes Tribunal of Bangladesh, the International Crimes Tribunal of Bangladesh 1 was established on 25th March 2010. Now let me remind you that we have achieved our victory on 16th December 1971, and the trial started from 25th March 2010. The tribunal was established on 25th March 2010. So the people of Bangladesh, the victims and the concerned people, had to wait for nearly 40 years to initiate the justice process for genocide, crimes against humanity, war crimes, and other inhuman crimes. The second tribunal, which was established on 22nd March 2012, but this tribunal is currently inactive. So the first tribunal is active, and it is still dealing with different cases on the crimes that I've already specified. Till today, the International Crimes Tribunal of Bangladesh has given judgment of 40 cases. And since I'll be just focusing on the genocide aspect and genocide trial, then I have went through all the judgments and found that in 22 cases out of 40 cases, genocide charges are being brought by the prosecution team. So as far as the rate of genocide charges is concerned, then 55% cases of the overall judgments or cases of the International Crimes Tribunal of Bangladesh involve genocide charges. Now, on the basis of the judgments of the International Crimes Tribunal of Bangladesh, I have tried to find out some trends of genocide trial. And the first one is number of genocide charges. There are total 195 charges which were brought in the 22 cases which involved genocide charges. And out of 195 charges, there were only 49 genocide charges in the 22 cases. So the rate stands 25.13%, which is more than a quarter. The second trend is genocide charges and mass killing incidents. So during the introduction of my presentation, I said that whenever we try to understand the term genocide, we have a meaning in Bengali, which is gono hotta. So when we explain genocide, then we understand that it means only killing. So in the International Crimes Tribunal of Bangladesh, there were many charges which were related to mass killing, but all the charges of mass killings were not the charges of genocide, because genocide requires some other elements. For example, as I said, special intent is important to prove before establishing a genocide charge. So there were 61 charges which were on mass killing incidents in the total 40 cases, but out of 61 mass killing incidents, there were 49 genocide charges. So all the mass killing charges were not genocide charges. So we cannot say that all the mass killings can amount to the crime of genocide due to the specific requirements of the crime of genocide. The third trend is acts of committing genocide. So in all the 49 charges of genocide, the common act of committing genocide was killing members of the group. But in only 2 cases, the tribunal found that even rape amounts to the crime of genocide. So in all the cases, as I said, in all the 22 cases, there was only one method that was mentioned by the prosecution team, and it was found by the tribunal that killing was present, and that was the main method which was adopted by the perpetrators to destroy the Bengali nation and Hindu religious group, Muslim religious group. Fourth one is group identification. So as I was just talking about the group, the common group which was targeted by the Pakistani collaborators and the perpetrators was religious group. And in most of the charges, the Hindu religious groups were targeted. So in all the charges of the International Crimes Tribunal of Bangladesh, this was the common religious group which was being targeted as being seen in the judgments. And some other groups, for example, national and political groups were also being found that they were being targeted by the perpetrators in some cases. For example, in some of the cases, the intellectuals were targeted to kill, and since intellectual group, it was not particularly a religious group, but they were being confined within the definition of national group. So in those charges, the intellectual groups were considered as national group, and then it was found by the tribunal that even killing the intellectual groups with a particular target amounts to genocide, because the perpetrators targeted the national group, which is, in other words, intellectual group. The next trend is conviction rate of genocide charges. So out of 49 charges, the tribunal decided that 27 charges were successfully established by the prosecution team. So conviction took place only in 27 charges out of 49 charges. So the rate is 55.11%. The last trend is punishment for genocide charges. So as I have went through the cases, and I found that in 16 charges, death sentence was given to the convicted persons, and in some other charges, a life imprisonment was given mostly to the criminals. Now, I'd like to tell you some of the challenges which was faced by the tribunal and the prosecution team during the trial of genocide charges. And through my study, I found 4 challenges to explain in this particular paper. So the first challenge was proving group requirement, because in most of the charges, it was found that the perpetrators targeted a particular community, and most of the people were from Hindu religious group, but there were some other people who were from Muslim, Christian, or Buddhist religious groups. So it was difficult for the prosecution team to establish that the perpetrator specifically targeted only on one particular religion. The second challenge is proving genocidal intent requirement. As I said, that there were approximately 61 charges on mass killing, but all the mass killings charges were not considered as genocide charges. For this reason, because even if the perpetrators targeted the groups and they have killed people in a widespread manner, but then due to the lack of genocidal intent, the prosecution could not successfully establish that it amounts to genocide or the perpetrator had a genocidal intent. So proving genocidal intent is always a challenge in case of genocide, not only in Bangladesh, but also in other cases. So it was another challenge that was faced by the prosecution team in the ICTBD. The third challenge is inadequacy of witnesses and evidences. As I said, that we took 40 years to get our justice through the International Crimes Tribunal of Bangladesh. So the prosecution team had to face a lot of challenges to manage witnesses, to make them give statements and testimonies in front of the court, and to produce evidences for substantiating their arguments. So it is, I would say, it is one of the most significant challenges that the prosecution team faced to prove the genocide charges. And the final one is changing characterization of genocide charges into crimes against humanity. In some of the charges, the prosecution team could not prove the genocidal intent, but they could successfully establish that killings happened or tortures or deportation happened. So the charges of genocide were converted into crimes against humanity just to ensure the conviction of the persons who are responsible for the crimes against humanity or genocide. Now, I'll just briefly talk about the Rohingya genocide aspect, and all the points have already been discussed by Dr. O'Brien. So just briefly speaking, there are 2 pathways for bringing justice for the Rohingya people. And the first one is individual criminal responsibility of the perpetrators, and the second one is Myanmar's responsibility as a state. If I talk about individual criminal responsibility, then there are 3 options. First of all, domestic courts in Myanmar, but it is quite unlikely to happen because Myanmar is still denying that they have committed genocide against the Rohingya people. So I don't think it's going to happen, or Myanmar is going to take an initiative to try the perpetrators who have committed the crime of genocide, because still they are denying. The second option is domestic courts in third-party states on the basis of universal jurisdiction. And we have already got to know that Argentina has accepted a case against the militias and Aung San Suu Kyi so that they can initiate the trial against the individual perpetrators on the basis of universal jurisdiction. And the third one is International Criminal Court. International Criminal Court has also authorized the prosecution team to investigate on the incidents that happened against the Rohingya people. So we are still hoping that International Criminal Court will bring justice for the Rohingya people by trying the individual perpetrators. But I wonder for one reason, because if the UN Security Council does not refer to this situation to the ICC, maybe the ICC's effort will not be that much successful, or it will be limited to some extent. And as far as the Myanmar's responsibility as a state is in concern, we know that Myanmar is a signatory to the Genocide Convention, and even though Myanmar has given reservation to Article 6 and 8 of the ICJ statute, but it does not bar the ICJ to deal with any case against Myanmar for states' accountability since Myanmar is a member state to the Genocide Convention. And this is because of Article 9, because Myanmar did not give any reservation to Article 9. So as per Article 9, any contracting party can bring any case before the ICJ if any country does not comply with the obligations which are brought under the Genocide Convention. And one example is, very vibrant example is the Gambia, because Gambia filed suit against Myanmar in the ICJ for violating the Genocide Convention on 11 November 2019 by making a declaration under Article 36, Sub-Article 2 of the ICJ statute. Now, I just would like to let you know some of the grounds on the basis of which the Gambia has brought a case before the ICJ. And the grounds are that the Myanmar has violated some of the obligations of the Genocide Convention by committing genocide, by failing to prevent genocide, failing to punish those responsible for genocide, and failing to enact necessary domestic legislation to effectuate the Genocide Convention. So I'd like to conclude my paper by saying that there is a commonality between the genocide aspect of Bangladesh and Rohingya, because the crime is common. The Bengali people were targeted to destroy by the Pakistani perpetrators, and they were being helped by the local collaborators. So the Bangladeshi people faced genocide, and they have received justice to some extent. Rohingya community is yet to get justice, but since they have also faced the crime of genocide along with crimes against humanity and other crimes, we hope that they will get justice one day. We had to wait for 40 years to get our justice, and we are still hoping to get justice because legal justice is not enough for the people, for the victims of genocide. And still 195 war criminals are yet to be tried. So they need to be tried to ensure complete justice to the people of Bangladesh. In case of Rohingya people, we can just quote one quotation from Elie Wiesel, who is an American-Romanian writer, who said, "For the dead and the living, we must bear witness." Thank you, everyone.
Thank you, Professor Hussain, for an excellent presentation on this justice for genocide. And you have made a very thorough study of our trial procedures which is continuing vis-a-vis the Rohingya genocide. And now I'd invite Hemanta Binte Farooq to make his presentation, a look at the International Crimes Tribunal of Bangladesh. Hemanta.
Thank you, sir. I'm Humaira Binte Farooq. I am representing on behalf of the museum. Due to some unavoidable circumstances, Ms. Camilla Agag, she couldn't come here. That's why I'm going to read I'm going to present on behalf of her. And the paper she wrote, the title is that the role and future of special courts in the international criminal justice, a look at the International Crimes Tribunal, Bangladesh. Until the establishment of the International Crimes Tribunal of Bangladesh, the culture of pursuit of accountability for the international crimes entailed seemingly giving more importance on fair trial, rights of an accused, than the expectation of victims to achieve justice. After World War II and the collapse of the League of Nations, there was a global initiative by the states worldwide to develop a global accountability framework for serious international crimes. The United Nations Security Council set up ad hoc international criminal tribunals such as the ICTY and the ICTR, which set the pace for establishment of ICC. Subsequently, the UN Residual Mechanism for International Criminal Tribunal, shortly referred as UNMICT, was established in 2010 by the UN Security Council for International to perform the remaining functions of ICTR and ICTY upon disposition of their respective primary mandates. The function includes tracking, arresting, and persecuting fugitives and to help the two tribunals complete pending trials or appeal proceedings. The only concern that the UNMICT, though it has its own statute, will import and apply some of the rules the tribunals. This means that the same operational culture and the shortcomings experienced by the tribunals will likely to be represented by the UNMICT. In 1998, more than 150 countries completed negotiations to establish the International Criminal Court, ICC, a permanent international court charged with prosecuting the most serious international atrocities such as war crimes, crime against humanity, and genocide. The ICC establishment saw to the noble attempt to have a central criminal court of last resort. After 20 years of existence, more than 50% of the world's population is composed of people not party to the Rome Statute. The ICC, a symbol of humanity's intention to ensure the accountability for the most serious international crimes more than ever, continues to experience fundamental challenges. Although all is not lost for the ICC, millions of people across the globe continue to endure the perils of war and atrocities in full glare of the court and the Congo, Sudan. The backdrop of international accountability for serious crimes was that the international court would intervene in the event where the individual state is unwilling or lack the capacity to persecute perpetrators. The Special Tribunal for Lebanon and the Extraordinary Chamber in the Courts of Cambodia was established in 2002 and 2007 respectively. The common characteristics of early hybrid tribunal is that they were formed pursuant to agreements signed by the respective states and the United Nations with global of bring to justice to those most responsible for atrocities committed during the country's internal armed conflict. Unlike the Rwanda and the Yugoslavia tribunals, the STL is situated in Sierra Leone, has jurisdiction over some crimes under the Leone law, and has judicial panels composed of international and Sierra Leone judges. Through these mechanisms, practice, culture, and precedents, the world has seen constructive development in international criminal law, including definition of crimes under the international criminal law, recognition of rape as a means of perpetrating genocide, definition of aggression and individual liability for the most responsible person and heads of the state for mass atrocities. The need for hybrid tribunals, special courts, or domestic tribunals with the character of the ICTBD, that stands for International Criminal Tribunals Bangladesh, stems for the challenges facing the Hague-based International Criminal Court that is viewed as the embodiment of accountability for the international criminal atrocities. At the helm of it is the limitation of cooperation, obligation to member states of the Rome Statute, over-reliance on cooperation, and the lack of enforcement mechanisms. Moreover, the statute does not provide for the reservation upon the ratification or accession. A number of countries and territories are also not party to the statute. This includes China, Singapore, Rwanda, Indonesia, South Sudan, Pakistan, United States of America, Nepal, Turkey, Iraq, Somalia, Qatar, Malaysia, Lebanon, Jersey, etc. The emerging issues and challenges facing international criminal justice will be discussed later on. Notably, international justice seemingly evolving in a shift to centralize more power to the individual state accountability systems rather than in foreign autonomous mechanisms. There is utmost rigor for maintaining internationally accepted standards of investigation, fair trial, and punishment. Since the establishment of the Bangladesh International Crimes Tribunal in 2010, it is no doubt that its trial and punishment have come under the critical acclaim as well as support. Thus, I will not be taking part the ICTBD's decided cases or legal framework for fundamental weaknesses or strengths. That area is certainly full covered by the other authors. As per the International Crimes Tribunal Bangladesh, there was a time when all efforts were made to erase the word Bangla from this land and its map. The existence of the word Bangla was found nowhere except in the term of Bay of Bengal. I, on behalf of Pakistan, announce today that this land will be called Bangladesh instead of East Pakistan. This quotation was made by Sheikh Mujibur Rahman on December 5, 1969. The liberation war between the West Pakistan and East Pakistan started in 1971 in a gruesome bloodbath and lasted for 9 months. In those days, Bangladesh was known as East Pakistan and governed by Islamabad. The Bangladesh in East Pakistan faced decades of marginalization from the government that consistently threatened to dominate the East. When momentum grew for independence, Pakistan launched a terrible crackdown on civilians that saw to the killing of tens of thousands of people within the first few weeks of the attacks. According to the decision of the General of Pakistan, which had been taken in a conference on 22 February of 1971, General Yahya Khan ordered the Pakistan army to kill 3 million of people, and the rest will eat out of our hands. Thus, the worst genocide of the history of world began with the Bangladesh genocide. The brutal Pakistani army's death squad roamed the streets of Dhaka and killed some 7,000 people, and most of them were civilians, university students, partly were an armed police and ER soldiers. In a single night and within a week, half of the population of Dhaka had fled and at least 30,000 people had been killed in Dhaka city alone. The war culminated in 9 months of rape, torture, extermination of intellectual, maiming, persecution, and is remembered as Mukti Juddha or Liberation War Museum by Bangladesh. In 1971, the Declaration of Independence was made electronically and on various radio stations. On 27 March 1971, the Bengali Army Major Ziaur Rahman read the Declaration of Independence of Bangladesh in English on behalf of Sheikh Mujibur Rahman, the Bangladeshi nationalist and hero who had been arrested pursuant to a brutal Pakistani military crackdown on 26th of March 1971. A wave of preemptive strikes ensued from Pakistan Air Force, and this saw the formal intervention of India on the side of Bangladesh. Within approximately of 13 days, the Pakistani army had been defeated on the both sides of Indian borders. In the Bangladesh front, Pakistani army surrendered on 16th of December 1971. And the nation of Bangladesh was finally established on the following day. The new country changed its name to Bangladesh on January 11, 1972 and became a parliamentary democratic country named as People's Republic under its constitution. Shortly thereafter, on March 19, Bangladesh signed a friendship treaty with India. The Liberation War of Independence is testamentally the worst genocide of the 20th century, reported to have been taken and estimated of 3 million lives. The Liberation War was established to commemorate the war as well as a history of 1971 genocide. After the independence, there was incessant calls for justice for the atrocities perpetrated during the war. This saw to the adoption of the legal framework of accountability. Bangladesh International Crimes Tribunal Act 1973, as amended by the Amended Act of 2009, in 2007, the Sector Commanders Forum of the Liberation War reported that war criminals committed 53 types of crimes in Bangladesh, including genocide, crime against humanity, and serious breaches of the 1949 Geneva Convention. And by 2008, the War Crimes Fact-Finding Committee published a list of 1,597 suspects. On March 25th of 2010, nearly 40 years after the war, the Bangladeshi government, by notification in its official gazette, set up the International Crimes Tribunal of Bangladesh, special domestic court to try the Bangladesh citizens suspected of collaborating with the Pakistani army to commit crimes against humanity in 1971. Section 3, subsection 1 of the Act empowers the tribunal to try and punish any individual or a group of individual or organization or any member of any armed defense or auxiliary forces, irrespective of his nationality, who commits or has committed in the territory of Bangladesh, whether committed before or after the commencement of this Act, any crimes listed under subsection 2 of this section 3 of this Act shall be tried by this court. The listed crimes within the jurisdiction of ICTBD are crimes against humanity, crimes against peace, genocide, and war crimes. Furthermore, Section 6 of this Act empowers the government to set up more than one properly constituted tribunal through an official notification in the Gazette. In 2012, the government set up another tribunal, namely International Crimes Tribunal 2, with similar jurisdiction as the first one, but with its separate rules or procedure. Moving on to the criticism part, like every other criminal justice mechanism, the Bangladesh Tribunal has received its fair share of criticism, both nationally and internationally. ICTBD verdicts and subsequent resulting executions have provoked protests, riots, and strikes, at which hundreds of people have lost their lives. In a comprehensive multi-chapter report commissioned and published by the International Forum for Democracy and Human Rights, a group of international lawyers, some of whose members have been involved in giving advice to counsel defending those accused on the ICTBD, Geoffrey Robertson sets out the background to the tribunal and evaluates its published judgments and appellate division of the Supreme Court appeals. The spirit of the report condemns imposition of the death penalty and execution of what he terms as political opponents. The tribunal's first decision to execute a defendant was condemned by the UK government, the US government, and the EU, and the UN High Commissioner of Human Rights, Amnesty International, and Human Rights Watch. In 2012, Human Rights Watch called for the suspension of death penalty. Criticism of the ICTBD mainly focuses on imposition of the death penalty and lack of fair trial insofar as it perpetually fails to meet international standard. In the article by Abdus Samad titled The International Crimes Tribunal in Bangladesh and the International Law, applauded the initiatives to address the impunity of perpetrators and offer redress to the victims of gross human rights violations, even as trial proceedings that do not follow appropriate standards for a fair trial and offer the right of due process should be depreciated. Moving to the conclusion, ad hoc tribunals and special court will change the face international criminal liability for war crimes, mass atrocities, persecution, and genocide. From the Nuremberg trials to the ICTY and ICTR trials that culminated to the establishment of the ICC, there is an inherent unmistakable will by the international community to address the atrocities. It is from this backdrop that ad hoc tribunals and special courts rose, evolve, and continues to thrive. The ICC still maintains wide support. It has fundamentally laid the basic for tangent development of international criminal justice culture that will see to the strengthening of the available system to achieve the rule of law. In an apparent shift back to the ad hoc tribunal, we saw the establishment of tribunals, such as extraordinary chambers in the courts of Cambodia, the special tribunals for Lebanon. The ad hoc nature of the tribunal limits the scope of jurisdiction of the mechanisms, hence presenting progressive development of practice in international criminal law. Conflict of balance between human rights and accountability. Limiting is not a permanent solution. Who is to decide whether one person whose action or omission results in the death of hundreds of thousands, if not millions of people, has a right to a fair trial? Several difficulties present themselves in obtaining a striking balance. In the research paper by Shojib Hossain titled Is the International Criminal Court Giving More Importance on Fair Trial Rights of an Accused than the Expectation of Victims to Ensure Justice? He explores whether the ICC as compared to ICTBD give more importance on fair trial rights of an accused than the expectation of the victims to ensure justice. He notes that the ICC applies an inherently accused-friendly justice, while the ICTBD eventually victim-friendly approaches to make a proper balance through legal frameworks and focusing on justice only which is expected by victims and survivors of the 1971 genocide.
Can you conclude?
So almost to the end.
I think you can go to the last concluding.
And lastly, in light of the emerging issues, there is need for serious changes from international pressure demanding justice. While calls for the international community condemning atrocities and human rights violation is an imperative, it is not a permanent solution. International criminal justice culture needs to be shift of focus to the protection of stateless person and ensure that through comprehensive definition of crime against stateless persons, an international mechanism may be set up on an ad hoc basis to address atrocity by the states not party to the statute against stateless persons or unrecognized countries. That includes her paper. Thank you so much.
May I now invite Regan Ahmed to make his presentation on the national and international perspectives of Myanmar.
All right. Good afternoon, everyone. Respected fellow presenters and honorable chair of the session, Barrister Amir Islam, sir. It is a great pleasure to have you. It is one of the primary significant reason to me being over here is because of you. Being an advocate primarily, so it gives me immense joy to have you beside me. And the topic that I'll be presenting today is criminal accountability of the perpetrators to the Rohingya crisis, national and international perspective to Myanmar. And Regan Ahmed, I'm an academician teaching at the Department of Law and Justice, Southwest University. Now, before going into the presentation, I'd like to take everyone to the preamble to the Rome Statute. Now, being an advocate, whenever we interpret a law, we always interpret a law keeping in mind the aims and objective of the law. It is always the most important motive to achieve the objectives of the law. Now, if we go to the Rome Statute, we see that one of the most important objective is affirming that the most serious crimes of concern to the international community as a whole must not go unpunished, and that their effective prosecution must be ensured. So by this, we can infer a lot of things as to what the Rome Statute intended, and the relevant stakeholders that are connected to the Rome Statute, ICC, must keep in mind in keeping the Rohingya issues. And the solution, we are hitting a lot of problem. What I believe is the problem is the strong mandate we need. It is not the United Nations referral, state parties referral, or the prosecutor's investigation. What I believe is there should be a strong mandate. For example, before I start, I guess I should give a particular thing to your notice is, 2005, the ICC had referred the matter of Sudan to the ICC. In that case, the then President Omar al-Bashir was found in accounts of genocide, crimes against humanity, and the ICC issued 2 accounts of warrant against Omar al-Bashir. But till today, Omar al-Bashir is at large. We couldn't hold Omar al-Bashir. Now, over here, the matter was referred by the United Nations Security Council, but ultimately, I don't think United Nations Security Council really had the resolute to go and further pursue the objectives of the Rome Statute. So over here, what is really needed is the strong mandate. Even if we know that without the Security Council, we cannot achieve a stronger mandate, a stronger justice, but a strong mandate, I guess, from all the relevant stakeholders is needed. All right, so before going into the main part of the topic, I'll summarize a little bit so that we can understand the basic or the foundation of the issue. Rohingyas, they have been systematically there has been a systematic and calculated persecution of the Rohingyas by the Myanmar government throughout the decades has resulted in forceful displacement. UNHCR estimates somewhere around 9,11,359 Rohingyas live in Bangladesh. But if you take into consideration the undocumented and the unregistered Rohingyas in Bangladesh, it may rise up to 1.2 million. Recently in 2018, an UN independent fact-finding mission found the state as well as the non-state actors to have committed the crimes of genocide, crimes against humanity, etc. United Nations High Commissioner for Human Rights, Michelle Bachelet, reiterates vehemently the same views. So she's also of the same view that they have committed the similar crimes. Zaid Rad Al Hussein, the then United Nations High Commissioner for Human Rights, also termed this as a textbook example of ethnic cleansing. Cowley also described as slow-burning genocide, and UN as well as Amnesty International also reports the same views. So it is, I guess, we all do have the inferences, the evidences, to whatever that has been gathered, that Rohingyas have been victims of the international crimes that are there in the Rome Statute. Now, conceptualizing the concept Rohingyas are Sunni, practicing the Sunni version of is the Muslim practicing the Sunni version of Islam, and there has been two views as to their origin. One is the 8th century, that they have come, that the Arab traders came to Arakan, and the second one is migration during the colonization by the British, and both the theories have contributed to the concept Rohingya in the Myanmar. So history leading to the present case, I would like to escape this one because we may not have time. All right, accountability of the perpetrators, national perspective. Now the main issue over here is, I would try to bring it into everyone's concern that actually why national accountability is not possible, and the relevant stakeholders connected to the ICC, even the Security Council, must take it into seriously. The Rome Statute gives primacy to the national court to investigate and prosecute the perpetrators. However, such prosecution and justice appears impossible as the perpetrators, including the military, including the commander-in-chief, occupy significant powers under the Constitution of Myanmar and the political administration. It is evident that even from the history, even after passage of almost 2 years, we haven't found any indictment to the prosecution of the serious crime that has taken place. And there has been 8 instances of 8 ad hoc inquiry commissions and board that has been set up since 2012, but none fulfills the criteria of independency, impartial, effective, thorough human rights investigation. So overall, nationally, we cannot expect anything good because the military has proper influence over the criminal and the military courts. Now, criminal accountability of the perpetrators, international perspectives. Rome Statute bears complementary jurisdiction to ICC in case the national courts fails to punish the perpetrators. The international ICC gets jurisdiction to try those. But in 4 cases, the ICC has jurisdiction. The first one is a crime of genocide, crimes against humanity, war crimes, and the crime of aggression. However, the ICC will only get jurisdiction only if such crimes are committed in the soil of a state party. And there are 3 ways, there are 3 mechanisms as to how this jurisdiction can be invoked is. First, the state party has to refer the matter to the ICC. United Nations Security Council, which is the most strongest because it doesn't require whether a party is a state or a non-state party. If a United Nations Security Council refers the matter, it may be tried. And last is on his own, when suo moto, the prosecutor investigate, and that is what the recent development has taken place. Now, there is a little bit of shortcomings, lacunas in trying Myanmar by the ICC. Myanmar is not a state party to the Rome Statute. Absence of United Nations Security Council resolution and limitation to the investigation powers of the prosecutor. As prosecutors generally, as they're in our law, the Rome Statute, the prosecutor can only investigate those cases that is well within the jurisdiction of the court. Now, well within the jurisdiction of court, all these days, keeping aside the recent development, we knew only the jurisdiction involved, the jurisdiction that was there within the Myanmar soil. or within only those crimes that has taken place in a state party. All right, recent progress. September 6, 2018, on a request, the ICC had determined that they had jurisdiction to try the crime of deportation. And later on, September 18, a preliminary investigation had opened. Later on, June 2019, the prosecutor notified his or her intention of opening an investigation, and recently that has been permitted, as discussed by my fellow presenters. Now, the challenges and issues for the ICC to hold the perpetrators accountable. Myanmar, a non-state party to the Rome Statute. Enforcement of the ruling, because ICC do not have any independent enforcement mechanism. Even if the pre-trial chamber, the ICC vindicates or indicts the perpetrator, I do not know how far this can be brought into justice, because in case the United Nations Security Council do not act, in those cases it is pretty tough to get the perpetrators. Case of Darfur region is a proper example in this regard. Absence of an United Nations Security Council referral, limitations of the prosecutor's investigation, and lack of significant will by the international community in submitting Myanmar to the jurisdiction. So I guess we need to, all countries together need to really intensify our efforts to submit Myanmar to the international court to try the perpetrators. Our findings: ICC only has jurisdiction over the crimes committed under Article 5, unless a crime of non-state party is referred by the Security Council. In this regard, Myanmar is not a state party to the Rome Statute. There have been no state referrals. Bangladesh, neither United Nations Security Council has referred the matter either in the territory of Bangladesh nor in the territory of Myanmar to the ICC. However, in September, the trial chamber, and that is what we know recently in a couple of days, the ICC, the pre-trial chamber 3 has allowed complete thorough investigation. Now, the thorough investigation, what I was going through right now, that anything that is connected to deportation. Deportation is mainly a crime that has started in Myanmar and it has ended in a state party. So through that interpretation, now they want to try Myanmar. The wordings of the pre-trial chamber was large, but I don't know how this is going to be actually jurisdictioned, because the matters that has taken place in Myanmar, I don't think they're going to submit to the jurisdiction of ICC. But in this case, we need the support and the support of the United Nations Security Council and all the countries together. National accountability at present is not possible. It also has impediments like Myanmar's unwillingness to cooperate, absence of its own enforcement mechanism. Rome Statute does not have its own enforcement mechanism. Prosecutor has limitation, though ICC recently has given the jurisdiction to try all the matters that are connected to deportation, but generally that is through interpretation, but we need to see in future pursue as to how far this prosecution investigation brings fruits to us. Myanmar state forces have been found to have committed all the crimes. Rohingya suffer from statelessness. All right, recommendations would be the international community must together as a whole pressurize in any way possible Myanmar to submit itself, because Rome Statute has a provision. Even if a party is not a even if a country is not a party to the Rome Statute, they can submit their jurisdiction. So in any way, even without the referral of the United Nations Security Council, if we can pressurize Myanmar to submit it to the jurisdiction of ICC, United Nations Security Council have failed. So I do think now they need to keep in mind the object of the statute and the object for which the Security Council was established, and come out with a stronger mandate to show as to achieve what they were brought in for. The pre-trial chamber must allow full-fledged investigation. That was one of the recommendations which has been allowed recently. United Nations Security Council, what I believe is there must be some sort of intervention. For example, even if United Nations Security Council fails, we have seen an example of Kosovo in 1999 when NATO had intervened. So in that case, even if United Nations Security Council, we cannot let the serious crimes go on. So I think there should be some sort of international presence in Myanmar in bringing this to justice. And Bangladesh government should come out of its failed policy of repatriation. Bangladesh, I do believe that Bangladesh only thinks about repatriation until that repatriation has failed. So actually the problem is not repatriation, the problem is accountability of the perpetrator. I think accountability of the perpetrators, if the perpetrators are brought to justice, I think all the solutions, all the avenues will open up. And all the state parties must, and this is pretty important, I believe, that whenever whenever the perpetrators are in any of the state party, they must try and hand over them to the ICC. They may arrest and they may hand them over to the ICC. Thank you. That was my presentation.
Thank you. We are about at the end of the session, but before we adjourn this session, it's very kind of Dr. Melanie O'Brien who have agreed to answer any question from the audience, if you have any. But then we'll have to end also very soon because there's the next session to begin the plenary 6. So, question, everyone. Do you have a question that you can articulate now? Yes.
Hello, this is Kazi Umar Faisal. I'm an academic. So my question is 2 questions. One is to Professor O'Brien and second for the chair. The first question is the case at the ICJ is still at the preliminary level, and as per the process of the court, it will go first from the decision and the jurisdiction, then merit. We don't know what will happen because the first case. So as far as remember, it resembles like New Zealand versus France, the nuclear weapon case, which is very close to that, and I'm not sure how far it will go. But if it fails, if there is any chance of bringing the case through advisory opinion. And the second question is to a chair, Barrister Amirul Islam. So my question is, since you were the law minister at the time of the enactment of our 1973 Act.
No,
so
no, I was not a law minister.
You were the law minister.
No, I was merely in the drafting committee of the Constitution.
Yes,
sorry, and author of the Proclamation of Independence.
Yeah, so I'm sorry for my mistake. So is there any scope of bringing the perpetrators of Myanmar Burmese army or government within the act, since it is deportation and our jurisprudence of ICTPD supports the question on element and the conducting question means that if it is travel under ICC statute, it also is travel under ICTPD. So what's your opinion on that? Thank you.
Thank you. I am Tabassum Islam Tamanna, third-year law student from Bangladesh University of Professionals. So my question is that I barely know about international law, but my question to Melanie ma'am that we know about the concept that dualism and monolism. So my question is that can universal jurisdiction be binding on the universal as whole? Since we know that if in Bangladesh, as we are a dualist country, so international laws are binding upon us. But what about Myanmar? If they don't want to take it as being a monolith countries, then what would be the action from the UN, or what would be the action of ICJ? So that's my question, that how this work, and will it ever be universal in the literal sense or not? So thank you.
Thank you for the questions. So if the Gambia case fails, will there be is there an option of advisory opinion? I actually don't think it'll fail because I think they've got a solid case. But if there was an advisory opinion, of course, it has to come from the correct body because the ICJ is very picky about who it allows to ask what question as an advisory opinion. So for example, in the nuclear weapons advisory opinion, it said that the World Health Organization was not qualified to ask an opinion about nuclear weapons because the World Health Organization is concerned with health and not security. And that was despite the fact that they were asking because nuclear weapons present a significant health issue after they're exploded. So if there were an advisory opinion, it would have to come from someone like, well, the Security Council would be the most ideal body, but it's unlikely that they would request one for the reasons that I outlined. But I guess the General Assembly would probably be the only body, and the General Assembly is a little more inclined to cover areas where the Security Council won't touch because, of course, there's no veto power. So I would say, yes, there would be a possibility if the Gambia case failed. But I think they've got a good case, so I'm fairly positive about it, actually. In terms of universal jurisdiction is not the law, so it doesn't bind everyone. So that's where we're at with that at the moment. It's something that people, it's a hope, and there are, the principle of aut dedere ad judicare that I mentioned, to extradite or prosecute, is more of a principle that has greater acceptance than universal jurisdiction. So basically, universal jurisdiction tends to be quite problematic in being able to be applied. And I mean, if you look, for example, at the case of Belgium, Belgium again was a small state like Gambia that was punching above its weight and introduced universal jurisdiction and started to take action against other people from other countries. And what happened was that they basically, it induced the ire of the United States, who then said, if you don't stop doing this, we are going to take away your NATO power, and we're going to take the NATO headquarters away from Belgium. So universal jurisdiction is certainly not customary law, because it's certainly not agreed upon, and it is vehemently opposed by some states, in fact. So therefore, it is incredibly unlikely that it will become customary law. Certainly not anytime soon, and I doubt even beyond my lifetime.
With regard to the Myanmar, as you have asked me the question, in Myanmar it's a very difficult country. It's so divisive, and it's ruled by the hierarchy of the Buddhist temples. And we at one point of time thought that Suu Kyi perhaps, when would be able to be installed as the head of the government, things would change. But that hadn't happened. She surrendered to the Takmados. Takmados are the name for the military. So it's a military who runs everything. And this, just before this Rohingya crisis which started, just I think a week or two back, there was a commission set up by the UN, and Kofi Annan came to Myanmar in order to study the situation, and he wrote a very excellent report. And the Kofi Annan report is a very, very important guideline. If that could be followed, then Myanmar could be one of the richest countries in the region. Because there is so much of wealth, so much of their mines, and rich country. But it is so divisive. There's Buddhist monks really dominate the society. And there's even the people who are not Buddhists, the people who belong to other religion, and they come from different areas, so they cannot have a proper movement in the night or up to the sunset. So therefore, they have to sometimes be kept under detention camps. So that's the kind of restricted society. And there is no cohesion in the society. So therefore, that report, which was Kofi Annan prepared, is an excellent report. And that could not be, before it could be implemented, that this crisis started, this expulsion of the Rohingyas and as a genocide committed, as they're killed brutally. Women were harassed, raped, and their houses were burned. So they came without anything, crossed the border to Bangladesh. And we don't know yet how this problem is going to be resolved. And we live in a system in this in the world today where there's a power, state powers, and the Security Council, which Dr. O'Brien had already told you in her opening speech. And this Security Council is the big powers really control that. But there is other way of getting interventions into these matters, which I think Dr. O'Brien will be able to tell you. And that's the process I think that many jurists can perhaps work out with him how we can, without having the Security Council, bypassing the Security Council, whether we can create a tribunal in order to meet this crisis that we are suffering here. And already the Argentinian groups who have already made some initiative, and I think that may help in building up a community of jurists to come to understanding how this trial can be initiated outside the Security Council's approval. So then I'll leave it to Dr. O'Brien to elaborate this further. No? Sure. All right? Okay. So in that case, I think we'll now, yes.
This is Tahsin Khan, faculty member, Department of Law, Notre Dame University. I have a question for Pizwa. So Pizwa, in your presentation, you talked about targeting the religious groups, national groups, and also political groups, and you explained them with examples. If I have not mistaken, probably you didn't explain the political group part. Can you please clarify that with example?
Well, there is no effective political groups there.
So the question is in relation to political group, and in one of the cases that I right now remember, which is Saka Chaudhury's case. And in that case, there was one charge which was related to political group, and the political group was basically Awami League group. In that particular case, the charge was in relation to like the perpetrators targeted the people who were in the opinion of Awami League. And at the end, during the trial, the tribunal found merit in that charge, and then it was finally concluded that since the perpetrators, with their intention, and it was within the objective of the perpetrators that they have targeted those people who are in the opinion of Awami League. So based on this, the International Crimes Tribunal of Bangladesh found that yes, they have targeted the political group. So this is the one example which is related to political group as I know in the International Crimes Tribunal of Bangladesh so far. Thank you.
So we have come to an end to the 5th session, and then we thank you very much, and particularly the distinguished speakers, and also for the questions that you have asked. And now we can end this, and the 6th session will start.
with that, we have come to an end of this interactive plenary session. And now I would like to request all of our guests to go up to level 1 for some light refreshment. And I would like to request to come back within 15 minutes. Thank you.
ফোল্ডারে ঢুকাবো ওইটা না মানে আগের সেশনে যেটা প্রিভিউ সেশনে এটা ফোল্ডার করে ফেলি বুঝলাম না 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 কয়জন পাচ্ছি তালা মারা না তো তুই এতক্ষণ কই গেছিস তোর নাম্বার বন্ধ কর
ভাই মোবাইল বন্ধ না তো ভাই মোবাইল চার্জ ছিল না বন্ধ
ওই একটা সেভিকে মাঝখানে পজিটে নামবো এখন থেকে আর পুরো পরিষ্কার করা লেগে কারে কারে রাখছি পঙ্কজ ভাই পঙ্কজ কি আরে
ওনারটা আফরিন যেটা আফরিন না আরফিন একটু ডেস্কটপে যান ডেস্কটপের ফাইলে যান
ডেস্কটপে যাবো আগে
আচ্ছা ওয়েট ওই যে ওই ভাইটা কি গোলাপি কালার শার্ট ভাইয়ের নাম কি উনি কিছু জিনিস ডিলিট করছিল ওইটার মধ্যে মনে হয় আরফিন ছিল উনি মনে করছে তা লাগবে না রিসাইকেল দিন দেখেন
এইমাত্র আমি কপি করছি বুঝছেন
কই সেটা
এই যে সিক্স ইন্টারন্যাশনাল কনফারেন্সের একটা ফোল্ডার করে এখানে একটা ফোল্ডার আছে এটা না
এখানে ছিল একটা আমি দেখছি
তাহলে এই যে এনেছি ওইটা
আরফিন নাম ছিল এখানে ছিল
আরিফিন নামে কি আমি ফোল্ডার কপি করে নিয়ে হলে খালি ফেলে দিছে
একটু রিসাইকেল দিন দেখেন না আছে নাকি
না এটা রিসাইকেল করে
আমি দেখছি এখানে ছিল
রেজিস্টার করব
হ্যাঁ রেজিস্টার করেন
আর বাকিগুলো বাকি কয়টা?
Ladies and gentlemen, we welcome you once again at today's last session entitled Empowerment of Rohingya Community and Future Possibilities. The panelists of this session are Mohammad Khalid Rahman, Pia Conradson, and Shahnaz Parveen. And the session will be chaired by Shahriar Kabir. He is a human rights activist and convener of Khatok Talal Nirmur Committee. Each panelist will be given 15 minutes to speak. The discussion will be then followed by a question-answer session. Now, we request the respective chair and panelists of this session to take their seats on stage. Thank you.
Which country you are from?
Blood-wise, Australia and Japan, but I live in Indonesia and...
Indonesia? Okay.
Yeah, but work here.
Okay. Also? Okay. আপনি তো আমাদের এখানে বাংলাদেশের আমাদের একটা পেপার আপনাকে দিয়ে দিই Good afternoon, ladies and gentlemen. We are already too late, running behind the time, and you are attending this conference since yesterday, and all of you must be very tired. So I'm not sure, because initial time was allocated for 1.5 hours, but I think it will be too long for us. So what we can do that for each panelist, we can have 15 minutes. Let us see the list of the panelists. 15 minutes would be okay. And I'm not sure how long we can allocate for QA session. I will take 10 minutes to sum up, and I have some suggestions and recommendations also. So first presentation, I would like to invite Mr. Khalid Rahman to present his paper. Please. Okay. Any problem? Is he going to present a PowerPoint presentation? Okay. So next, Pia, would you mind to present it?
Yeah, I also have a PowerPoint.
Okay. But is it ready? All of the panelists are going to present. It's a PowerPoint presentation. Okay. Yes. After the Shabari. This is great. So then I would like to request Ms. Pia Conradson for presenting her paper. Okay, Pia? Okay. Can you do it from here, or you have to go there?
Oh, I can either way.
Yeah, I think it's good. Yeah, why not? Huh? Oh, control ওখান থেকে করতে হবে. Oh, it should be control from there. Sorry, dear.
Good afternoon, everyone. Thank you so much for coming to choose this session. Please bear with me. I'm very nasally, as well as having a broad Australian accent. So, yeah, please bear with me. So, since February 2019, the Liberation War Museum and Ajar, who I work with, we've been working with a network of over 87 women inside the Rohingya refugee camps. So today I wanted to share a bit about our compiled action research with this informal network of women and what we've found working alongside them for the past year. So we created a process of listening in with these women and facilitating workshops using participatory action methodologies to learn together about different human rights and justice principles. And since the start and now, the purpose has always been to, number one, strengthen the voices of these women survivors. Two, to take steps to strengthen their capacity for practical community action, and to also strengthen our understanding as an organisation and as a museum here of the causes and impacts of violence against women, and to try and seek opportunities to advocate for them like we're doing today. Now we're still continuing to facilitate these learning circles on gender justice inside the camps, and today I want to show you some of the research methodologies we use, some of the key findings, and most importantly, stories from these women. So the key findings from the research have been pretty important for the development of our further programming and understanding the lives of these women and how we can raise their voice. But the main focus of my paper and the presentation will be looking at more of the ways and methods that we've been using to work with the community to teach basic rights and justice, and how to make these lasting connections with the refugees. And personally, I've always believed that education about human rights should be accessible to anyone, and particularly those whose rights have been violated. And as a lawyer, our job is to make the law easy for other people to understand, but we tend to do the opposite and complicate it even further. So the good news for any law students out there is that there is a less soul-crushing way than the billable hour in an office to work with the law. So yeah, a big challenge for us was how to work with this community who are largely illiterate, suffering unimaginable trauma, and in a very constrained environment, both socially and physically. So as I said, I want to focus more on the process and methodologies, how we use them, what we learnt, and more importantly, what the women have learnt, and highlight different ways in which you can work for justice and accountability at the local level. So AJAR, together with Liberation War Museum, continue to adapt these methods from a manual that AJAR developed called Stone and Flower, and it's a guide to help facilitate a process to help women better understand issues related to their experience of conflict and impunity. And I think I see some faces in the audience here who have actually come to our training center in Indonesia and learned a bit more about these methodologies too. So over the past year, we've learnt how to sort of adapt to the reality and rhythm of the camps, understanding the different dynamics of these group of women we work with, adapt to what they find interesting and engaging, as well as learning best practices on how to facilitate learning human rights in this context. So this process has included a variety of methods to document their stories, work on community-based healing. So I call this holistic law because I, for the first time, studied law, but I'm learning about how to heal victims too. And simply looking at a way to improve their everyday life. So for an example, as a way to teach basic human rights, we created these cards, which you can see on the slide here. Each of them are representing the different Universal Declaration of Human Rights. And on one side of the card, we had an illustration made, and on the other side of the card, we had the rights in in Burmese, in English, and in Rohingya. So this was accessible particularly for the illiterate community too, because they could find someone who could read. And so once they got to learn the images, they could recognize what image represented what right. And that was really useful in learning about it, because if we talk about something, those who couldn't read could still identify using the picture. Yeah, so this has been a really great tool for them to understand the UDHRs. And this is another methodology that we used. we called a hand mapping, and it was used to sort of discover the identities and the stories of these women in a much more intimate way than just simply taking an interview. Some of the women grew up in the camps. They were born and raised there, so they were there before the large exodus in 2017. So some of you may be able to read the Bangla on one of the hands there. And we got to learn a lot about each of the women in a much more intimate way, how they expressed their identity, explaining the activities that they did with their hands back in Myanmar, and now what they do in the camps today. So we want to highlight how important it is that the struggle of impunity must be a process that is accessible to victims and stakeholders of justice at the community level. As many people across the globe, but particularly we see in Asia, this struggle to continue to combat impunity, using this participatory approach can really contribute to a deeper understanding of the issues and help support women who seek to address the many challenges they face in the struggle for justice. So while the key findings using these methodologies and what we've learnt about these women have been really important for our understanding, what is equally important, if not more, is how this process actually heals and empowers the participants. And in this paper, I want to focus more on the healing powers of art and using creative methods to express ourselves, and a really good tool to learn about human rights. So as you've seen in the exhibition upstairs, we asked women to sew a panel of either their hopes and their dreams, and with 120 stories, we put them together for this collective voice, and it sent such a strong theme and messages, and we learned that these women are very hungry to learn, and it was a great tool to learn about their pastime, but it also was an opportunity to remind them of what they enjoy doing with their time. And if you've had an opportunity to look at them, many of them express desires that they want justice, or they want equality for women, or that they want more education opportunities. So this is another way that we can get that information from the women in a very expressive way that is more true to their practices that they do, and sewing was also a common pastime for them in Myanmar. So a big part of empowering the community, particularly this community who have suffered mass human rights violations, is looking at how we can work against this impunity. And for us, the transitional justice framework has always been a great tool to explore how conflict has affected a community. So transitional justice, I'll just say now, is it consists of both judicial and non-judicial measures implemented to redress legacies of human rights abuses. And these include criminal prosecutions, truth commissions, reparations programs, and different types of institutional reform. So I mentioned that we have a training manual called Stone and Flower, and on the slide is the activity that is Stone and Flower. So you can see 4 quadrants, and each of them represent a different aspect of the transitional justice framework. And we wanted to understand how women felt that they had experienced in their lives any of these areas. So in the first quadrant, you can see truth. And the stone represents a negative feeling towards truth, maybe that they don't feel that the world knows the truth. And a flower represents a positive perception, that they do feel that the world knows the truth. So immediately, we can visually see how these women experience conflict and feel about truth in their life, whether they have freedom from justice, freedom from violence, whether they feel justice, and whether they feel healing. And you can see that in the quadrant for justice, it's just all stones. And this was a really great way for the women to see themselves, what they've experienced. They said to us, we've experienced all of these things in our life, but for the first time we can actually see it in a tangible manner. And this is something that they can also easily replicate in their community too. So they can use the UDHR cards with the pictures to represent their different rights, and they can easily find a stone or a flower, and they can do this activity with the community too. So from these tools, we can discuss with women really important questions such as, how do they feel that we can ensure that the world knows their truth? And what is their truth? Because we don't decide that for them. It's the community who decide what their truth is. And how can we stop violations, and how can their community work towards justice and accountability? So as everyone knows, with 1 million refugees in the camps, there are so many dizzying aspects. I mean, even in the last day and a half, it doesn't feel clearer, it feels more confusing. Human trafficking, climate change, cyclone threats, threats of extremism, hate speech, social media. There are just so many factors that keep on exacerbating and being on top of each other. And then inside Myanmar, we have a weak rule of law. There's a gathering storm of identity politics where polarization, extremism, and intolerance are being used by those who are powerful to continue to divide victims. So while these mechanisms are really important, and it's been an incredible week for international justice, they are of course critical and necessary for change, but they can't be the only tool. So when we do have a push for accountability, we need to use this principle of what I like to call a slow cooker versus fast food. So justice has to be built on a strong foundation, or it might crash land. And our experience in the camps and what we've seen in other contexts is that these foreign-led initiatives will have very little effect unless there is a parallel movement supporting truth and justice inside that community. And so with this slow cooker, it takes time. It's about building trust, and when you develop a program, it's not about putting all the ingredients in at once and just making it come together. We have to add little bits at a time and make sure that we build that connection with the community in this very long journey for justice. So from these methodologies, we do find a lot of key findings about the experience of the women. Some of them include, and I go into them deeper in the paper, is that violence against women persists even in the camps. Widows and single mothers are particularly discriminated against. And the women hold such an importance of education for their children and the next generation. And actually, I just want to look at the story based on this point of Lucky. Maybe you saw her quilt in the exhibition upstairs, but I absolutely love her name. She chose it herself. She was 9 years old when she fled Myanmar. She was in a crowd of, I think she says, about 30,000 people fleeing Myanmar to come to Bangladesh, and she was separated from her parents in a wave of people coming. And the trauma was so impactful on her that she forgot her name. And so she came to the camps, and she found an auntie. I'm not sure if it's a biological auntie or someone who she calls an auntie, and that auntie has looked after her for a while. But her auntie already has 10 biological children of her own. In the camps, there's limitations as to how much money you can earn as a refugee working, which on average is about 500 taka per day. And to send a child to an informal school there to learn the Burmese curriculum is 500 taka a day per child. So if two working parents are earning 1,000 taka per day, they can only send a maximum of maybe 1 or 2 children to school. So Lucky is not able to attend school anymore, but everything that she talks about is about her desire to learn English and get an education. And this is her sewing here. She sews the English alphabet because that's what she wants to learn. And I'll just quote here. She says, "I want to go to school and learn English, but I cannot afford to go. In camp, we can only go to school up to class 5. While during this, I remembered my parents." So this is just one person, but it's a story of many of the young generation there. So this is a very pertinent issue for the women, is about the next generation for their kids. And some other findings include that the women need special programs and improved spaces to deal with trauma and help other women. There are a lot of different centres, women-friendly spaces, but many of them are not as inviting for the women, in their words, as being able to work in their own shelters, in their own community, in smaller groups. So I think that there needs to be a push for more safe spaces for these women. And another thing is that Rohingya women often lack information and are often left out of decision-making processes as well. And for instance, with the lack of information, it's even as basic as where they can obtain simple medication. So it's not even at the high level decision-making processes, as simple as maybe someone who needs a wheelchair doesn't know where to find a wheelchair. So I think I'm maybe at my time limit. I wish I could talk more about all of the different stories from the camps, but I hope that we can continue to find creative ways like the quilt to shed light on these women's stories and work together on different ways that we can work with this community on justice and accountability, and to present them to people in forums like this and the wider community. So yeah, that's all from me. Thank you.
Thank you, Ms. Pia, for your brilliant presentation. I'd like to request Muhammad Khalid Rahman for your presentation. Is it in the brochure, the paper we presented? Is it published? Yeah. Yeah, okay.
Honorable Chair, dear panelists, ladies and gentlemen, good evening. Actually, the topic I have prepared today for presentation, it has three aspects. You can see it from here, from the title, that the urge of Rohingyas, what do they actually need? And number two, the violations that have been, that Maraw had performed against them, and what could be or what should be the legal solutions. And number three, how the Rohingyas can be repatriated or be returned back to their homeland. Myself, Mohammad Khalid Rahman, working as an assistant professor of law at AIUB. See, 2 months earlier, I have been in the Rohingya camp working on working on a project, and actually that project is on making a film documentary on Rohingya issue. And I have interviewed different Rohingyas personally and in a focus group discussion. And they have talked to me on different issues, different matters, and they have told me what are their sufferings, how they survived the brutality, and what are the circumstances here at the camp, and what they want to do in future. You see, you have heard that on a few days ago, when they have celebrated 2 years here in Bangladesh, they have gathered in the Kasas Bajar Madhuchhara camp, camp number 6, for get together, and they have said that they have 5 individual points to be fulfilled by the international community, by the Myanmar. They want citizenship of Myanmar, they want safety and security of their lives, they want resettlement in their home. The international community must keep on pushing the Myanmar government to establish trust and meet their demands. and the International Criminal Court must try and punish the Myanmar military officials and mobs. You see, actually I find out these 5 particular principles, these 5 particular points from themselves. Let us come to the first part, that the legal solutions of the atrocities committed by Myanmar officials, which actually been described in a very fine manner by my previous panelists in the previous session. So you all have come to know all about the ICC procedures, the ICC mechanism, the ICJ mechanism, and the Domestic Criminal Court mechanism, and we have discussed these things, for several times. So I should rather pass this slide. Actually, these treaties have been signed and ratified by Myanmar, and why this slide is important, because it is actually a thing that you should know, that how Myanmar can be bound by the international law. And all is about ICC, what's the procedure of ICC, and the very interesting thing what actually happened in the last week, that in the 14th November, the Pretrial Chamber 3 of the International Criminal Court authorized the prosecutor to proceed with an investigation for the alleged crimes within the ICC jurisdiction in the situation in the Bangladesh/Myanmar. So it is really a very good news for the situation. Though Myanmar is not a party to the Rome Statute, which established the ICC, the Chamber concluded that the court may exercise jurisdiction over crimes when part of the criminal conduct expert on its territory or for a state party. So you see, it's really happening out there. The ICC has taken their foot down and they say that they have the jurisdiction. So it's really a very good news for those who are working on this particular situation. And the next slide is about ICJ, and ICJ for taking, you see, you have already know that Gambia has filed a case against Myanmar in the ICJ. And how Gambia can file a case that this thing, while Myanmar has made a reservation to Article 6 and 8 of the Genocide Convention, it has a reserve to Article 9. As a result, any contracting party to the convention, that means the Genocide Convention, that has not made a reservation to Article 9 may bring a case against Myanmar. So therefore, that's how Gambia can file a case, and it's the first time that Gambia has filed a case against Myanmar. And it is not only against Myanmar, but also it's against in the history of ICJ. And we have already discussed several times about Domestic Criminal Court, and recently a case already has been filed in Argentina by local lawyers and Rohingyas and activists. So let us come to the second point, that how the Rohingyas can be repatriated. You see, Bangladesh has been bearing this burden for more than 2 years now. And can you imagine, this is the largest refugee camp all over the world, and Bangladesh it's already been overpopulated for a long time. And see, I have already told you that I have been in the Cox's Bazar, and I have been in the camp, and I have been in the camp in the monsoon. And if I have the privilege to show you the video footage I have taken in the monsoon season, that is actually horrible. Just you can't imagine that how the Rohingyas are living there in the Rohingya camps, and this should not be scenario, because you see different Rohingyas, different persons, they are telling me that, telling me that, can you imagine that you are living in this camp, living behind your own house? They are living in the Arakans, they are living in the Rakhines, Kachin, and Shan, and their houses are in a very good position. They have they're very big houses, they are very big stores, and they are roaming freely in their villages. Though they have some limitations outside their villages. So there are several times Bangladesh has tried for repatriation for Rohingyas. And unfortunately, both time Bangladesh failed. And let us not go for why Bangladesh failed, let us go for how or what will be the next situation or position that Bangladesh can take or Bangladesh can think about to repatriate the Rohingyas to Myanmar. Okay, let me clear one thing about first that there are two perspectives. The first thing is that the perpetrators should be brought under justice, and number two, that the Rohingyas should be repatriated. You see, these two things are connected. Okay, so whenever, on my thought that whenever we're talking about only, bring justice for the perpetrators, this should not be, done without thinking of the repatriation of the Rohingyas. So these particular two things should be interpreted harmoniously, should be thought harmoniously. So from my perspective, I have sorted out some solutions of repatriation of Rohingyas. And first, the revision of repatriation agreement, which has been signed by Bangladesh and Myanmar on January 2018. And there are some, you see, there are some provisions which should not be there in the particular agreement. First thing, that this is an agreement and this is not legally binding. So therefore, Bangladesh cannot bound Myanmar to return back the Rohingyas. And more of all, that Bangladesh is very much, very much want to use the principle of non-refoulement. And therefore, whenever about the principle of non-refoulement is going to be used, Bangladesh cannot push them back by force. The Rohingyas should be going back to the Myanmar voluntarily. So from that perspective, another one thing that in the agreement, there is no time limitation. So it might be 2 months, or it might be 2 years, or it might be 20 years from now. So from my perspective, that the repatriation agreement should be revised. And another thing is that the amendment of citizenship law of Myanmar of 1982. You see, it is all about anthropology, that about the development or the history of Rohingyas in Myanmar. That anthropologically, Myanmar are living in, Rohingyas are living in Myanmar since very long time, since the British. Okay, so therefore, but the thing is that Myanmar is trying to, conceal the fact, and they impose the fact that the Rohingyas they don't declare Rohingyas as a citizen. So you see, all citizens are entitled to get civil and political rights, but unfortunately, Rohingyas don't get civil and political rights, or even right to life in some particular extent. Number 3, proper implementation of the recommendations of the Kofi Annan Advisory Commission. Actually, I focus on the particular report very much, because you see that particular commission has been prepared mainly by the members of the Myanmar, by the citizen of the Myanmar, the nation of the Myanmar. Therefore, only Kofi Annan is the foreign national in the commission. But all other persons are here from Myanmar, and therefore this particular report of the commission should be implemented by the Myanmar. And I already know that they have made a particular commission to implement the recommendations of the report. Okay, so and another thing is that the citizenship law compliant with international law, and you see, as Myanmar is the signatory party of Refugee Convention, and in the according to Refugee Convention, Myanmar has to obliged to maintain the rights of not only the nationals or citizens, but also to the stateless. So the thing is that the particular citizenship law is not compliant with the international norm, and they have to make amendments on citizenship law. And review of citizenship verification. Citizenship verification should be made properly by the Myanmar authority, ensuring human rights to the Rohingya. And we all know that the fact that Rohingyas have been brutally tortured, murdered, raped, persecuted, abandoned from their own house, from their own country. And in order to ensure their return, the human rights should be maintained. The human rights should be performed by the Myanmar. And finally, creating secure environment to promote repatriation. You see, whenever I'm talking to the Rohingyas about this thing, they're very much afraid of this thing. They're thinking that if they return to Myanmar, they might get killed. So you see, they don't have the belief, they don't have the thought that they might get well treatment. Rather, they're thinking they are getting killed. So, especially from the statements from the Myanmar authority, what we thought that actually they are they're taking more time, and it's intentional, and they are not very much interested to take them back. And for that reason, they are creating that fear among the Rohingyas intentionally. So in order to take them back in the Myanmar, the secure environment is very much essential. So that is the concluding part of my presentation, that actually see Rohingyas are living here. We call them the forcibly displaced Myanmar nationals. The UNHCR, they've said the Rohingya refugee. Some people say they're Rohingya community. And I personally like to say Rohingyas. You see, they're stateless, they don't have home, they don't have any country, they don't have any place to die in peace. Therefore, they don't have any place to go. So that's my question. Where should the Rohingyas will go right now? We have to put our foot down. Thank you very much, everyone.
Thank you, Mr. Khaled Brahman, for your wonderful presentation. Next panelist is Ms. Shahnaz Parveen. She is going to discuss on the distribution of water filtration systems among Rohingyas and the knowledge associated with their usages.
Good afternoon, everybody. I'm Shahnaz Parveen. Thank you so much for inviting me here in my motherland. I'm doing PhD in Moscow. This is my second year. This is just starting. So I think it's my 6th conference, international. Although I'm not good at talking, but I'll try my best. And thank you all the organizing committee and all the members who have done this job, because without you, this program cannot be like this, successful, I think. And now I would like to present a paper on the distribution of water filtration system among the Rohingya refugees. So the structure, there will be introduction, theoretical framework, and the solution. The interaction, there will be a problem. I will address a problem. And what is the problem? The problem is, I will not say Rohingya. I'll say the people who are living here, who came here when they have the problem, and we give the shelter. But what is the problem? I will today discuss about the waterborne disease, how they're drinking water and how they're getting sick, and how to do this solution, and how to actually adapt them with these good things. I will discuss about these things. And the next slide we'll discuss, so the waterborne disease. So we can start the presentation by discussing the problem that I want to address. The problem of access to clean water by the Rohingya is characterized by two dimensions. The first dimension relates to the presence of the water itself. What is not evenly distributed among the Rohingyas. It is appear, however, that 73% of the hand pump for water are functional. Accordingly to the International Migration Organization, and that there is a water point every 47 person. As a comparison, the standard is to have one water point every 250 person maximum. So it seems that the scarcity is not a critical factor. The problem of access to clean water is however different. About 76% of Rohingya currently using the excess water, which is contaminated by various pathogens. And what are the pathogens? I'll tell you that one is Escherichia coli, what is the bacterium that causes diarrhea, and hemorrhagic colitis, that is the beaver cholera causes. And the pathogens of cholera disease, this is the thing that they are drinking every day. Therefore, the problem of treating the water becomes critical, and there is a common belief among the healthcare community that the water is the possibility of a pandemic waterborne disease among the Rohingya is high. To this regard, Bangladeshi government has started vaccination program to removing the contact between the population and the pathogens. It appears that today barely any treatment attempt to the water consumed by the population is made. Water filtration systems are partially in place and appear to be used by some. But overall, the population doesn't take steps to ensure that the water they consume is treated before consumption. In the theoretical framework, we'll discuss two theories, and we'll find what is the result we will get. One is the theory of diffusion of technology, and this is I took from sociology, sector of sociology. And one is the theory of health behavior change, that is the sector of medicine. And all this technology tools means you may think that this is technology like engineering or something. No, this is not something like this. I will use it as tools, actually. The people who are using like shari, you know shari, you are very known to these things in our country, or maybe clothes I can refer. This is the tool I will refer as a technology. And this, we will start by using the primary theories related to the diffusion of technology in a population, and then we will see how the connecting the adoption with the modification of the population's behavior, we can link to the retention of desirable behavior towards sanitation and water treatment. The diffusion technology. Diffusion means the distribution. So we can, first of all, mention in the context of this research, there is no difference between the words technology and innovation. This is important because literature on innovation means non-technological forms of innovation, such as social innovation, which are not interesting for us today. What is interesting for us today is the study of the theory related to the way in which a technology previously absent in initially diffused to a population subsequently adopted it. We also pay no distinction between the words diffusion and adoption, because we are interested only in the measurable outcome of the diffusion, that is in the factual uses of the technology being diffused. Here there will be three proximity: organizational, geographical proximity, cognitive proximity. Organizational proximity is something to adopt the technology we need to organize actually. As geographical proximity will refer that it's the technology as close to possible to the people actually who don't know anything. We need to provide the technology. And cognitive, this is thought, and people understand the general term like this way. We need to provide this. And now I'll tell the theory of the change in health behavior. Actually, in one word, if I were to say, all the models here I will present that says it's possible to change human behavior by changing human thoughts. And all the models are human thoughts actually. So in general, cognitive behavioral models discuss the behavioral and cognitive methods that at the individual and collective level can be used to modify the behavior. The behavioral component corresponds to the modification of the behavioral itself. And we can consider it as output or effect that we want to cause. In the context of this problem, we are studying the desirable modifications in the behavior is the uses of treatment system for water before the consumption. The cognitive aspect relates to cognition, that is the symbolic and analytical thinking of the human, whose behavior we want to influence. The cognitive behavior methods methods for modifying the reasoning, whether explicit or implicit, of human towards a behavior that we want to keep. So here we'll see three approaches. One, biopsychological approach. What is the joint intervention of biological? That has to be done by the organization. And self-determination, actually, this is something whom I will change. He need to be self-determined that yes, I want to drink that clean water, not that dirty water. Or if I think that no, in this machine, whatever here, maybe they will kill me, maybe it is poison, maybe they are killing me. I need to be self-confident that I will do the best. The people who are drinking already, I will not die with this water. There's another model that's called B. That is the capability, opportunity, and motivation. This is the combination of this model, which refers respectively to the psychological, physical status of the individual, to the social expectability, to the behavior which should be undertaken, and to the internal psychological factor, whether impulsive or rational, which determine the action chosen. See how to promote this adoption of water filtration system and the adoption of healthier behavior. We have seen how the cognitive plane is the most important plane accordingly to the theories of health behavior change. But the geographical and organizational proximity cannot be forgotten. We'll now see a small list of ideas that could increase the organizational, geographical, and cognitive proximity between the Rohingya population and the uses of water treatment system and techniques. So we can start by discussing the organizational proximity. It is not realistic to involve the Rohingya population in the logistic or an organizational aspect related to the procurement and distribution of the water filtration system. It is not realistic to involve them in the maintenance also and operation, because maybe Maxim doesn't have the education, or maybe some have, but maybe, I don't know, maybe they don't have the, as far I have the interviewed things, I have the statistics that I know that they don't have this knowledge of operation or maintenance. So I think this local community or local administration should take this. It might, however, be possible to assign to them small tasks related to the supervision of the system, which would be a way to insertion of technology adapters into the population. cost for this measure should be might high and might help access to the population. Cost for this measure should not be high. But to help the access network of the people directly benefiting from the technology by means of word-of-mouth communication. This is how we will actually do our first measurement. Actually, this means that water treatment system have to be deployed where population collects the contaminated water. In another way, treatment system will need to be deployed to the place where the population fetches water if we want to maximize geographical proximity. Actually, you cannot put the machine where they will be afraid. Maybe if you want to make a kitchen near to their house and you want to establish a water pump or water plant, maybe they will afraid. What is this? Let's do something that what they already know. Like they know these lakes. So maybe if we put something near there, maybe they will think that, okay, this is maybe water. This is something maybe we can drink or maybe we can take for our living. And now we will see the another measurement that is called filtration of those sari clothes. It is actually common. It's called frugal innovation. So, which relates to the technology innovation, which is possible on the basis of resources which are available in the territory of the population being studied. The first such measure relates to the filtration of water through clothes. It's appeared that the population of rural Bangladesh filters contaminated water through the shari clothes. And there is some evidence that is the technique might reduce the amount of bacteria and vibrio cholera found in water. But chemists must examine this proposal as because maybe this is not true, maybe this is not realistic in the certain geographical area because maybe the water is really populated or contaminated, I'm sorry. So I should, before drink or before the sari things, filtration things, the chemist must take this. But this is also a proposal from me, actually. And we'll see the next one. That is, you can see a tree. It is called xylem. In Asia, it is really a familiar tree. And this is not actually too much costly. It is not unhealthy like sari also. You can find near India, Myanmar, Indonesia. It's really available and it's not costly. Also, we need to buy only a small pipe. By this small pipe, we can also add this bark. We need to remove the bark. After that, this way, we need to put the bark.
Ms. Shahnaz, can you conclude by 1 minute?
Yeah.
You have crossed the time.
So this is a tested by a chemist, and it's already actually proved that this water is something bad. They can drink it, and it is not populated. It's not contaminated. There is no something Escherichia coli or vibrio cholera. There is no something like this. And this tree's name is xylem, and you can tell it Pinus cassia. I'm sorry, I need 1 to 2 minutes.
Please conclude.
There is another thing. We actually have been looking for the symbolic or linguistic explanation of this new machine. You can see the two machines. This machine is already in their camp, but they don't know that it is drinkable or not because they think that this is poisonous. This is why 40% of the Rohingya people don't drink from this machine. So we were trying to find this something called Thigian. This is a Myanmar festival, water festival it's called. So they use this flower. You can see the flower. It's yellow. So I was thinking if we use this flower as a sticker in the machine, so maybe they will think that this is a water festival or something, and this flower actually indicates that healthy life. So maybe they will think that this flower, if we put there, maybe they will drink. Thank you so much.
Thank you very much, Ms. Shahnaz, for your interesting presentation. Now, ladies and gentlemen, we have 15 minutes for Q&A session. If you have any questions, our panelists, they are ready to respond, or any comments, that we'll appreciate it. So, is there any question? Yeah, from there. Please introduce yourself. Then
Sure.
put the question. Yeah.
My name is Timo Leimeister. I'm from Germany, but I work in the Philippines. I have one question for Pia Konradsen. Fantastic presentation. Thank you very much. It was interesting to listen to you. I was wondering if you were facing any kind of challenges during your work. And like, given that I also work in peace building, we also have to deal a lot with like traumatic stories, like a heavy emotional background of violence and conflict. How do you cope with avoiding re-traumatization, you know, through storytelling or like through getting those memories out again after they were buried for some time?
You asked about the challenges that we face, but I've been told to respond very briefly, which is quite difficult because there are many to talk about. But in terms of the re-traumatization, this is what I talk about, the slow cooking and the methodologies that we use is that we don't pose a certain question that will require the women to evoke these traumatic things like they can. So for instance, with the hand mapping, I'll just use that as an example because you saw it. It gives an opportunity for the women to choose what kind of experience that they want to talk about. A lot of the women do want to talk about the positive things that happened to them, but those who wish to share some of the harder things that happened to them, then it gives them the opportunity to. And we create these learning circles where we have a lot of kind of pre-activities to build that trust and to ensure that it's a really safe space for these women to talk about it and be ready on their terms to talk about what happened to them. And we've been working with them for a year now, and you know, some of them are only talking now about what happened to them, and now that they feel that it's the right time that they can do that. So but other women do just want to explicitly express what happened to them. And this is where we hope that we can work on referral services too for anyone who is seeking help. At the same time, a lot of the services are by local Bangladeshis, so there's a bit of a language barrier. And we found that now the women actually talk a lot to each other about what happened to them. So I hope that answers your question briefly.
Thank you, Pierre. Any more question? Yeah.
Hello, my name is Ilina. I work for a peace-building organization in Lebanon, and I've been working with Syrian refugees since they arrived, since they started arriving in 2011. And one of the things we have been facing in Lebanon and broader in the countries hosting Syrian refugees is a growing tension between the refugees and the host communities. A lot of this is based on host communities facing similar challenges and feeling underserved and feeling that a lot of the attention goes to the refugees. I'm wondering if the experience of your organizations have identified any issues that are similar for the Rohingya community and the Bangladeshi community, and if there are any openings for creating spaces for communities to engage in dialogue and to meet, to spend more time together and overcome emerging concerns, fears, or stereotypes of each other.
Okay, could you please mention whom you want to respond?
My question would be primarily to Pia with her experience from the camp, but if the others have ideas,
Talking
I'll be
about
really
the
happy
tension.
to think about.
Okay.
Yeah,
So-
drawing on understanding of needs in the camp and what is
Khalid,
in
do you
common.
like to respond? Or I can talk in my concluding remarks. Yeah, I'll mention this problem in my concluding remarks. It's a very important observation about your experience, what you said. So, yeah.
I am Shuman Borua, World British Association in Bangladesh. Our Shahriar Kabir Isaac questions: how can a role play international community and Bangladesh to solutions Rohingya issue? Thank you.
Thank you. I will respond later during my concluding remarks. Thank you for your questions. So any other questions to the panelist? Is there any other question for the panelist?
I'm interested in what kind of information Mr. Rahman can give us about the conditions for filmmaking in the camps generally, or particularly the one that you were in, as far as support, as far as restrictions, as far as whether you've given the camera to the Rohingya themselves when you were not there at times, whether you felt difficulties doing that, and in particular also, who's helping you? Have you got a company that that is helping you, or a foundation or an NGO that is backing you up? Because I'm concerned with the matter of distribution. We will see tomorrow afternoon a remarkable film in which the woman who made it, Shahida Teleganova, she just decided to make the film and took her camera in there and sort of did it, and then had to go through quite a bit to get it, in fact, in distribution. But she was able to do it and get it into distribution with the help of a number of activists, some of whom are here and some of whom are not. So that's a whole sort of context in which you operate interests me.
So should I? Okay. Thank you. At last, someone is asking about this thing. Thank you very much. Actually, it is like this, that I have the camera and I went to the camp and I shoot photos, that's it. But you see, there are some complications, there are some legal barriers. I took permission from RRRC and my university helped me there to get permission. And I have my volunteers, my students are my volunteers, and I have some specialists helping from different organizations, like Melanie is here. I get few help from Melanie. You see, I'm not only an academician, but I'm also a photographer. But the thing is that I'm also thinking about my students. I see the students in my university, they want to do something for the society. So they came to me, and they approached to me, and they said that, sir, we should do something for the Rohingyas. Then I said, then let's go. Let's do something for the Rohingyas. Then the people will think that, the people at large, they will think that what should we do about the Rohingyas? Because you see, whatever we're talking about in these conferences, people actually, they know less. They don't want to actually bother. The practical things that they are very much aggrieved right now about the Rohingyas. Whenever I'm talking to, I've also been in Maheshkhali Island, and I'm talking to the local fishermen, and what they've said, that they don't have job, they don't have food, because the Rohingyas are there, and they took all their jobs and something else. So see, it is not like this, the conferences, it's not like the papers. The people should be get reached. So therefore, I took the decision, and I go there by myself. And I have few friends, I have few students who will help out there. Thank you very much.
One more question.
Mine was more of just a quick observation, so perhaps we can do both the observation and the question. The observation was for Ms. Parvin. Just to note that one of the interesting things about the camp is that, unlike several of the other refugee camps in the world, this camp has not had an outbreak, a massive outbreak of cholera. And that's something that quite a few of those working in the humanitarian sector have spoken about, because there was an initial approach to ensuring water cleanliness when the refugees first came, or ability for their systems to manage bacteria and whatnot in the water. Another thing, just as an observation to note, is that I spoke with a WASH specialist, a person who specializes in sanitation and hygiene, and that person noted that the problem is really at the water pump, where the water pump water is coming out. So they can get very clean water to the water pump, but then the water pump itself very quickly becomes contaminated. And to continuously keep the water pump clean entails having people that are present there to ensure that the water pump is being cleaned, and or that special drops are being inserted into the water. And it's with the drops that I think the poison concern that you raised comes up. So I think additional elements to look into as you're continuing to delve into this, specific to the Rohingya camps, is to consider options both around filtration, but also about addressing some of these knowledge and other concerns that deal with the pumps themselves and what people can be doing when they're there. And also the usage of those pails that they use to collect the water, because the filtration won't address that. Once you filter the water and you put clean filtered water in dirty pails, you're again stuck. So it's a really complicated issue, and I'm excited that you're looking into it.
Thank you so much for your comment. As far I took some interviews from them, I talked to them. Actually, they don't speak my language, but I used someone from like Myanmar, some colleagues. We took the interview. They actually don't believe that this water is safe. I take this information from them. So I also asked them, do you think that how we actually had this survey since they accepted my, what should I say, they accepted my abstract. So we were surveying everything about this presentation. Here is all the references there is in the slide, in the last slide. I actually think that according to their opinion, this is not only my opinion, this is our opinion, I must say, that they say that they think that the water is not safe and they don't want to drink. They don't want to take the contraceptive pill also. I also heard these things from them. They think that whatever God is given, this is pure. This machine is not pure. They think these things. So this is why I was searching for something natural, like this flower. They think that this flower is something healthy, long life for them. The Thingan, the English is water festival. So they use this flower. So there you can see, there is a filter, and there is a something coming from water from the very deep. And he don't use this one. He used that one. He preferred that one. Why? Because he don't know. And nobody's there for teaching. And this is why I want that if I could put this sticker, maybe this is not so much costly. Maybe this can help them that, wow, this flower here, okay, this is healthy, so I may drink it. I don't have the education, I'm uneducated. But if I see the flower, maybe I will be, my actually unknown mind will say that, yes, I can drink this. I can use this for my life. Or also, they can use the shari if they don't want this one also. Actually, there will be less, at least contaminated things. This is how I actually found these things. Thank you.
Any more question? I thought that it is the last question. So this is the last question, please.
Yeah, I am Venerable Lablo, and as I am agree with the professors, and he's talking about that there are many of the problems with occurrence with the locals people, and then even we are the Muslim peoples in Bangladesh and Rohingya, but we are still growing up in our mind
or the hatred each others because of some issue. So my question, the professor and also Honorable Shahriar Kabir, how will be reconciliations with these things and how will be fixed about that of things in futures? Because when we saw there's people from the Rohingya, that is means we from our heart already making discriminations, and also some of the bad things is coming in our heart, and they say, oh, this is, we are always, when we talk in the foreign some places, oh, we are a Bengali Buddhist or we are a Bengali Muslim. Oh, they are not our nations, they are our only religious. But still have it there. So how can you make reconciliation, and how can you make two party to the make one platform, the make inner peace in their side, to without non-discrimination and without the hatred, because hatred always create the hatred. We have to be love and compassion to how we develop their change their behavior, make the good positive thinking of our two parties, the Rohingya Muslim and our Bengali Muslim. So this is the two questions. The question is both of you are teachers, my dear.
Okay, since time is very short, let me respond it. So we have heard 3 brilliant presentations and quite enlightening presentation from 3 panelists. And let me tell you something beyond this. The question I've been asked, what is the solution? And you also mentioned about this question of hatred, which we are observing. One of the guests already raised this issue. Yeah, we are observing this problem situation because you know that the root cause of this problem, the Rohingya crisis, how it developed. It is, though the panelists, they mentioned, Mr. Khalid mentioned that it's the Rohingya Muslims. Well, we already set up a commission to investigate into Rohingya genocide. We have visited Rohingya camps. It is headed by very eminent, Supreme Court retired judge, Justice Shamsul Huda, and Justice Shamsuddin Chaudhary is a member secretary of that commission. Mr. Julian Francis is here. He is also a member of that commission. We visited Rohingya camps, and we have recorded 10,000 testimonies of the Rohingya victims of genocides. Whatever they said, that it started in the name of religion. I know that, and we all know that if we go to the history of genocide, most of the genocides were committed in the name of religion. If you look into the Bangladesh genocide during the Liberation War of 1971, definitely it was in the name of religion. For the sake of Islam, those Pakistani establishment and their fundamentalist allies, they killed 3 million people for the sake of Islam. They raped officially 200,000 women for the sake of Islam. So in Myanmar also, some of the Buddhist monk, you know about monk Viratu and some others, though we know that Buddhist religion, it is the most peaceful religion. I wrote the history of laws of war, and I was looking into the laws of war in the religion. I have found in Judaism, in Christianity, in Islam, in Hinduism, there are laws of war. But when I looked at the Buddhist in scripture, and there I couldn't find any law because there is no conception of war in Buddhism. But how it happened? If you look into the monk Biratu's statements, last year Time magazine published a cover story. That title was The Jihadi Monk. And he said it categorically that we are not going to tolerate any Rohingya Muslims in the holy soil of Myanmar. So they were, joining hand with the Buddhist army, and as a result, these people, they came here. But what was the backlash? And suddenly we observed there is the fundamental Islamic militants and fundamentalists taking the advantage. They started a hate campaign against the Buddhists of Bangladesh. There were some incidents here and there in Chittagong, in Dhaka, the Buddhist monks particularly wearing this shafted clothes. They were lynched, and it was not recorded or published in the newspaper, government intentionally, and we think so that it shouldn't be mentioned. But it was started. Then we immediately set with the government establishment, we talked to the foreign minister, what is the solution? And at that time, in our commission, there are some Buddhist leaders also, including Shuddhananda Mahathero, and who is the supreme leader of this Buddhist community of Bangladesh. And you know, in the Buddhist religion, there are hierarchies. You know better than me that you have some kind of pope system that, well, they are honored. When Mr. Shuddhananda goes to, you know, Burma, in Myanmar, Aung San Suu Kyi stands in front of him. She cannot sit in front of him until and unless she is permitted. So this is the hierarchy they maintain in Buddhist, you know, religion. We know that. So we requested our government, the foreign minister, that you should send a Buddhist, high-profile Buddhist delegation to Myanmar to talk to Aung San Suu Kyi, not only Aung San Suu Kyi, to all the Buddhist monks there. I'm quite sure not all the Buddhist monks in Myanmar, they support Biratu or this kind of atrocities in the name of Buddhism. Well, it is yet to be considered, you know. And again, we suggested that, we asked our government as well, that we should call an international Buddhist conference in Bangladesh. Why some people in the name of Buddhism, they will commit this type of genocide? We have seen in what happened in Sri Lanka. So some people are attacking mosques and some people are attacking churches, and you know, this is in the name of religion, any kind of atrocities or genocide or any kind of hatred we cannot permit, and it needed to be addressed properly. So I think there is a need to go for interfaith dialogues, but as well as the conference that we suggested, that we can invite Buddhist monks from Myanmar, we can invite Buddhist monks from China, Chinese backing, you know, Myanmar, this regime, repressive regime. We can invite monks from, you know, India, Sri Lanka, and other countries, you know, let us discuss. Because in Myanmar, Buddhism plays a very major role in politics or in social life. We cannot deny that. But again, you know, I have seen some Buddhist monk from Rakhine State, they strongly criticized Monk Biratu for his hate speeches and other things. So this is one solution. But what our Prime Minister said in the last United Nations session, let me mention about 4-point program, what she raised. The solution she mentioned about Myanmar must manifest clear political will supported by concrete actions for sustainable return and reintegration of Rohingyas to Myanmar. Number 2, Myanmar must build trust among the Rohingyas by discarding discriminatory laws and practices and allowing to go and visit the northern Rakhine by Rohingya representatives. Number 3, Myanmar must guarantee security and safety of Rohingyas by deploying civilians monitors from international community in Rakhine State. And number 4, international community must ensure that the root causes of Rohingya problem are addressed and the violation of human rights and other atrocity crimes committed against the Rohingyas are accounted for. So accounted for, this is very important what Mr. Khaled Rahman also said, that accountability is the only one good for justice, and the process already has started. YC has taken initiative from the day one. We are asking our government or other bodies, international, national bodies, those who are perpetrators of Rohingya genocide, they must be brought to book. As we campaigned for trial of the Bangladeshi war criminals of perpetrators of Bangladesh genocide. And very recently, you know, last month, we arranged an international conference in Geneva, in United Nations building, inviting all these, you know, genocide studies experts and other who were concerned about doing genocide, you know, campaigning against genocide across the world. So there, you know, let me quote the 4th, you know, resolution. We came out with a 3rd alternative. We know that what Prime Minister Sheikh Hasina said, that is the only way. They must go, and Burmese regime, Myanmar regime, should create the atmosphere for safe return of the Rohingyas and ensure the citizenship and other things, security and citizenship, everything. But if that doesn't happen, what will be the alternate? If they don't listen to you, definitely there are many alternatives, you know, like, you know, these Islamic NGOs and Jamaat-e-Islami and other political organizations, and they're crying, well, let there be a jihad against Myanmar, let us capture Arakan and set up an independent Rohingya Muslim state, and that is the solution they are going for, and they are campaigning for this solution since 1999. Because we are investigating Rohingya genocide not from now. Since 1999, our organization, we have received some of the, these jihadi materials. They are campaigning to fight a jihad against Myanmar regime. So, and they have a design. It is a grand design that comprising a part of Arakan and part of Bandarban, part of Cox's Bazar, there should be an independent Rohingya Muslim state. So this is the design of ISI. I don't like to go back to the history. It's a long history we are monitoring. I wrote extensively on this. So this is a design. There's some Islamic NGOs. They are working there, and they're promoting, they are recruiting, taking the advantage of the vulnerability of the Rohingya refugees. They are recruiting them for jihad. They have provided arms training. In my film, Portrait of Jihad, you see, not the recent one, the previous one, There I have interviewed one, activist of Rohingya Solidarity Organization, and he said, frankly, that how he has been recruited by Jamaat-e-Islami when he came to Bangladesh, and first he was trained here for higher training, he was sent to Libya, and they fought jihad, and they died, they call it shaheed, many of them, they become shaheed fighting jihad against Myanmar regime. So this is going on. But another alarming, issues that came to our knowledge, at that time I was traveling to USA. On 13th June of this year, while I was in New York, I have seen a news that one very eminent US congressman, Brad Sherman, proposed to the Congress committee for a solution, and he appreciated Bangladesh's position, how Bangladesh, sheltered Rohingyas, he appreciated everything. And finally he said that since Myanmar regime is not willing to take them back, so the only solution is the annex of Arakan and join Arakan with Bangladesh. And America is ready to help Bangladesh in this process, that it should be annexed from Myanmar and the Rohingyas should be settled in Arakan. Next week, I met Congressman Brad Sherman in Washington, D.C., in Capitol Hall in his office. I just thanked him for his concern for Rohingya problem, Rohingya crisis, but I said that the solution and the formula you suggested, that will lead a war with Burma. And we cannot afford a war, and our Prime Minister from day one, she is telling that we want to solve this problem peacefully, diplomatically through dialogue. But well, if dialogue doesn't work, what is other option? We are going to, this YC has gone to International Court of Justice. Well, it is not a guarantee for repatriation of Rohingyas. It is a guarantee, or it is initiative for trial, or to bring the perpetrators into the, book. But definitely, these people are not going to, attend or, welcome this trial process. And Burma is not a signatory of this, ICC, or they are not going to, they have no respect to this human rights or whatever you say, Universal Declaration of Human Rights or United Nations resolution. We have seen since 1962, there were several sanctions of Myanmar by international community, including economic sanction, continued for many, many years, but it never worked. While America is putting economic sanction on Myanmar, the American multinationals are doing very good business with Myanmar, Myanmar, different companies in Myanmar, because for economic reason, business reason. So this kind of sanction, I am not sure how far it is going to work. The third alternative, what we suggested in the Geneva Convention, let me read out. Well, it is absolutely our organizations that that we are representing Forum for Secular Bangladesh, and we have that Citizen Commission. What we suggested that the conference would like to propose the consideration of a third alternative that had been adopted by UNHCR in the past in the cases of Palestinian, Afghan, Syrian, and Bhutanese refugees who were relocated and in developed countries, enlisting the Rohingya population now languishing in refugee camps in Bangladesh in that UN list for relocating refugees in developed countries would at least ensure the persecuted and displaced Rohingyas a chance for lead better lives. It's the third alternative. I talked to policymakers, I talked to the foreign minister, but they are not ready to accept this formula. Till now, they said that, well, since we have signed, MOU with Myanmar regime and we are promised bound and Myanmar government is also promised bound to take them back, let us work on this. But it is up to you, and if you go for third alternative, well, third alternative is a long discussion. The way our Prime Minister also mentioned in her speech in United Nations, the problems created by the Rohingya refugees, we have set an example of humanity. Our Prime Minister is called, Mother of Humanity. But Mr. Khalid mentioned, and you also mentioned about the conflict and tension between local Bengalis living in Cox's Bazar and the Rohingya people. The forestry already been destroyed, more than 9,000 acres of forestry totally destroyed. The animals and the animalhood, it is totally, disturbed, and law and order situation collapsed, and the livelihood of the local Bengalis, it was also, collapsed, the economic life of the local Bengalis, and it is creating a tension. At the same time, it is not a tension between the Bengalis and the Rohingyas. In 2012, what we have mentioned in our white paper about the incident in Ramu, you remember that in 2012, there was an attack on several Buddhist temples and the Buddhist neighborhood in Ramu. Who were behind this? Well, in our white paper, it was mentioned that it was the Rohingyas, because they don't like to see any Buddhist in that area. Because they say that, and Jamaat-e-Islami said that it is the Buddhists who are responsible for killing of Rohingyas. So this is the Jamaat-e-Islami's design. We have to be very careful about this thing. Right now, I have received the message, and that is about the Jamaat-e-Islami's, design in South Asia. Just day before yesterday, there was a hearing in the US Congress, and some of the US congressmen also expressed their deep concern that very soon South Asia is going to fall into a very serious, conflict. It is going to become a conflict zone because of the Rohingyas. Many, many international game players are there. So this is an alternative. Well, I am not sure how far, but well, definitely we have seen in case of particularly, let me give you one example. In 1992, 150,000 Bhutanese refugees, Bhutanese people, they went to Nepal, took shelter in Nepal, and Bhutanese, they said that, Bhutanese regime, they said that, no, they are the citizen of Nepal. There is no place for them in Bhutan. And Nepal said that definitely they are not they are the citizen of Bhutan, and we are not going to accept them. It is the same case with the Rohingyas, here we have, the Burmese regime is saying that they are not citizen of Myanmar, they are the citizen of Bangladesh. Ultimately, United Nations intervened, and it is a long discussion, a resolution adopted, and they suggested for third country relocation. And 150,000 Bhutanese refugees are now relocated in different European countries, including America. At that time, while talking with Congressman Brad Sherman, I mentioned that you have sheltered 90,000 Bhutanese refugees. Why not you take some of the Rohingya refugees here for temporarily sheltering them? And the YC is coming out with a proposal of trying them. But well, YC can come for sheltering them. Already Canada have suggested last month, you have seen that they are ready to take 200,000 Palestinian refugees to Canada. And New Zealand also came out similar suggestions. So this is nothing new, a relocation in third country. As you know, Bangladesh is the most densely country in the world. And this small land, it is the largest refugee camp in the world. All you have visited these refugee camps, how in inhuman condition these people are living. Well, we don't have enough land to provide them. And whenever our government suggested they should be settled into one island, Bhashanchar and others, well, the international community and the human rights organization, they created a hula baloo. Oh, no, that will be a prison camp for the Rohingyas. Let them stay there. How can they stay there? And how long? So this is one alternative. I think that we have to, this is a very serious issue. The Liberation War Museum, this international conference have taken up. And I do hope that Mofidul Bhai is here, that at the end of the conference, you should adopt some resolution, and it should be sent to the policymakers, including United Nations. That's why we arranged the session, international conference in Geneva last month in United Nations. So the pressure from United Nations and the member countries, particularly from the European countries and the US, there should be a strong pressure. Without pressure, just with dialogue, with MOU, it is not going to work. How naively we are treating with them, well, they don't have any respect for, sorry to say, democracy or human rights. So, ladies and gentlemen, it is enough for now. You know, you are attending the conference since yesterday, and tomorrow there are more important sessions. So let us conclude here. Thank you very much for attending this session. Thank you, the panelists and the guests. It was in 2012. Several Buddhist, neighborhood.
We'd like to thank Honorable Chair and the panelists for such a wonderful session. We'll come up with more sessions and discussions tomorrow. Thank you so much for staying with us till the end. See you all tomorrow. Thank you.
That was a fake, That was a plea. Plea to it. It is fake, And that guy who is also, the Uttam, the young boy, he disappeared. They have killed him. A similar thing happened last week, 2 weeks back in Bhola. One Hindu boy's Facebook was hacked, and somebody mentioned some derogatory remark about Islam, and entire Hindu neighborhood was attacked by these mullahs. So it is quite common practice in Bangladesh, hacking one Hindu or Buddhist Facebook, and you will make some derogatory remark about Islam. Yeah, for the bloggers also. Yeah, young bloggers.